Hello friends, welcome to my YouTube channel, Attorney E Immigration Lawyer. Today's episode, pag-usapan po natin ditong US Citizenship Act of 2021. Ito ang proposed immigration reform ni President Biden, which was submitted to Congress on February 18 of 2021. I'm going to talk about this proposed law base dito sa summary that was given to us by the American Immigration Lawyers Association. So, ang aming po organization, ALA, I've been a member for more than 10 years. Before we proceed, I want to introduce myself dun sa mga hindi pa nakakakilala. My name is Attorney Elaine Antonio Bordeaux. I'm licensed in New York. I've been practicing U.S. immigration law for more than 10 years. I represent clients from all over the world on their U.S. immigration matters. Every Friday, meron kaming free consultation, eb@eboardlaw.com, 713-315-7793. Nandiyan po sa screen ninyo. Okay, so very excited ako dito sa Biden immigration bill. Okay, and then this was submitted both in the Senate and the House of Representatives. Okay, so itong bill na ito, kino-cover niya yung path to undocumented individuals in yung reformation ng immigrant visa system para dun sa family reunification. Yung ang tagal-tagal na natin mga naghihintay ng mga Filipino. And because marami po kasing Filipino applicants, applications na ang petitioners ay galing sa Philippines and limited ang immigrant visa, kaya po mayroong mataas na backlog po kung galing po sa Pilipinas. Meron din pong reform on employment para dun sa mga graduate students na nagtapos sa STEM. Ayon dito sa Biden immigration bill ay maaari silang mag-submit ng application for permanent residence. Of course, hanggat hindi po ito maipasa ng Kongreso, tama ba? Until it's passed by Congress and signed into law by the President, ay hindi pa po ito batas. Okay? Ito po ay isang bill pa lamang. At may proseso po ito katulad po ng pagpasa ng batas sa Pilipinas. Dito sa Amerika ay mayroon din pong proseso. Okay, so we're gonna go over this. Ito po ay hindi, itong presentation na ito ay hindi substitute sa actual consultation with your immigration lawyer. Okay, no attorney-client relationship is formed by watching this presentation. Okay, number one, papalitan na ang salitang alien. Ang termo ng alien will be replaced by non-citizen. Ito po ay condition of being a non-citizen. So, hindi nagagamitin ng alien. Title 1. Napaka-importante. Earn path to citizenship and other reforms. Okay. Magkakaroon ng isang status, ang tawag po ay Lawful Prospective Immigrant Status. Ito po LPI. Ito po ang status para doon sa mga undocumented. May mga requirements po, criminal security check, and then of course paying fees. Ang initial period of authorized admission for a lawful prospective immigrant. Okay, so based dito sa fact sheet, the bill allows undocumented individuals to apply for temporary legal status with the ability to apply for green cards after 5 years if they pass criminal and national security background checks and pay their taxes. So ang ability to apply for green cards, dapat pa 5 years nang nasa Amerika if they pass criminal and national security background checks and pay their taxes. Okay. Ayon po dito sa proposed immigration law, the initial period of authorized admission para dun sa LPI, ang status is 6 years. Mabibigyan ng documentary evidence of LPI status. And ang LPIs ay ito po yung mga undocumented na may 5 years, nakapasa ng criminal and national security background check at nagbayad ng mga taxes. They will be authorized to work. They can travel and mabibigyan din sila ng social security number, and they will be allowed to join the U.S. Armed Forces. Okay? And then after the LPI status ay mabibigyan sila ng pagkakataon na mag-apply ng permanent residence. So LPI for at least 5 years remains eligible for LPI status. Hindi naging absent sa US for more than 180 days. Lahat po ng federal taxes ay bayad. Ay maaaring mabibigyan ng permanent residence status ayon dito sa proposed law. Okay. So sunod na importanteng provision, pinili ko po ito dun sa nag-a-apply sa ating mga Pilipino. I'll do my best to finish in one session. Medyo mahaba po siya. Pero salamat po sa AILA, American Immigration Lawyers Association, for this summary. Itong the DREAM Act. Ito po gusto ko kasi ito yung mga batang nakarating sa US. Nung maliit lang, nung bata pa po sila, mababait po ito, they went to school, nag-aral, and then they were granted DACA. Recently, they won, diba? Kasi during President Trump's time, ay pinahinto po ang initial application ng DACA. And then, before he left the White House, ay inutusan naman po ang USCIS ng court na mag-accept na ulit ng initial application for DACA para dun sa mga na-deny or hindi po nakapag-apply na qualified. So ayon po dito sa proposed law na ito ay ang mayroong DREAM Act na nagbibigay ng green card or permanent resident status sa mga DACA recipients para sa mga dreamers po. Sila po yung mga kabataan na they entered the US young when they were below 18 years of age, younger than 18 years, may high school diploma, GED certificate, or high school equivalency diploma, naka-obtain ng associate level leading to bachelor's degree, mayroon pong nakapag-serve ng armed forces for at least 2 years, or honorably discharged at or nagkaroon ng income for at least 3 years, working at least 75% of the time the person had valid work authorization. Para dun sa may mga work authorization, ito po yung mga DACA recipients, sabi, 3 years na nag-work, at least 75% of the time the person had valid work authorization. Except for people enrolled in higher education program, and they would get credit for that time toward the 3 years. At nagpa-register sa selective service if required. Okay? Yung spouses and children of people eligible also may apply. So yung mga asawa, anak, ay pwede ring mag-apply for adjustment. Yung rule barring DACA recipients from having access to Affordable Care Act are being rescinded. At yung 5-year requirements for accessing Medicaid and CHIP are also not applicable. Provisions are also included making DACA recipients eligible for FHA, Rural Housing Service, Fannie Mae, and Freddie Mac mortgages. So po pwede silang mag-avail ng affordable housing. Sabi ko nga na binabasa ko to para ko nasa langit. Alright, but mahal po natin itong mga dreamers natin. Mga kabataang pumasok sa Amerika when they were kids. Mga wala pong naging problema sa batas. They went to school, mga estudyante, mga naghanap buhay. I represented so many of them. And to know na meron ng bill in Congress para mabigyan sila ng permanent resident status ay napaka-importante po. Itong American Promise Act para dun sa mga TPS and DED recipients, yung mga katulad ng nationals from Liberia, Venezuela, El Salvador, Haiti. Ang TPS ay binibigay para dun sa mga nationals ng ibang bansa na nagkaroon ng problema. Kung say political crisis sa kanilang bansa o kaya nagkaroon ng disaster na matindi at hindi parang for humanitarian reason ay hindi mo na parang wala naman pong we need to accommodate them dahil napakatindi ng disaster na nangyari sa kanilang bansa. at wala silang ibang mapupuntahan. Katulad yung nangyari sa Haiti, di ba? And this is the American Promise Act. Kasama ito sa proposal, Section 1104, na nagbibigay ng green card para po sa kanila. Okay. Meron din pong Section 1105, the Agricultural Workers Adjustment Act. Okay. Tayo po mga Filipino ay kasama rin tayo sa H-2A program. We were suspended, yung Philippines was suspended for 1 year, if I'm not mistaken. Ang H-2A ay suspended pa rin, pero ang H-2B ay balik na po. Okay. So ito po yung mga H-2A ay yung mga agricultural workers. Ang sabi po dito sa proposal ay 5 years immediately preceding the date on which the non-citizen submits the application, the non-citizen nakapag-perform po ng labor at least 2,300 hours or 400 work days. Okay? At ito po, ayon dito sa proposal na ito, ay adjustment of status na or green card na po. Maganda po ito. So ang tawag po dito ay the Agricultural Workers Adjustment Act. All right. Yung tungkol sa criminal history naman, expungement. Nako, tinatanong ako, attorney, na-expunge na po. Iti-declare pa po ba namin yan sa immigration? Paano po ba yan? Okay. Right now, ang expungement ay wala pong epekto sa immigration. Maraming dahilan kung bakit nagpapa-expunge, di ba? Yung iba po ay dahil sa trabaho because once meron ka ng criminal history, may mga states na pinapayagan ng employer na mag-inquire into your criminal background. At yung ibang states ay mahirap maghanap ng trabaho kung meron kang ganyang background. So yung iba nagpapa-expunge po. Maraming dahilan, pero that's one of the reasons. Ngayon, unfortunately sa immigration ay wala pang epekto ang expungement. Pero ayon dito sa proposed law na ito, ang Biden Immigration Reform Bill, ang definition ng conviction ay binabago. Hindi na niya isasama kung ang adjudication or judgment of guilt has been dismissed, expungement, or expunged, deferred, annulled, invalidated, withheld, or vacated. It also does not include adjudications where a court has recommended against removal, an order of probation without entry of judgment, or any similar disposition. Also, judgment on appeal or within the time to appeal don't count. Okay. Importante kasi ang provision na to, say, ang isang non-citizen ay nag-a-apply ng citizenship. Okay. So, kailangan pong may consequences ang bawat criminal conviction. Pero itong particular provision na to ay binabago niya ang definition ng conviction na hindi niya na isinasama kung na-dismiss, na-expunge, na-deferred, na-annulled, na-invalidate, na-withheld, or na-vacate. Okay? Para dun sa mga residents naman ng CNMI, yung mga kababayan natin, mga non-citizens na nasa CNMI, pati Guam. So, Section 1207, relief for long-term legal residents of the Northern Mariana Islands. H-1Bs working in Guam or the CNMI will not be counted against the annual count. Hindi na sila makikasama dun sa annual count. Allow DHS to establish a process for eligible non-citizens to apply for CNMI resident status during the 180-day period beginning 90 days after the date of enactment. Because like say in Saipan, which is part of the CNMI, ang dami po nating mga kababayan itong Filipinos na contract workers na nandun sila ng matagal na and hindi sila nagkaroon ng opportunity na maging permanent resident. Of course, yung mga iba nakapag-asawa, nagkaroon ng anak, pero yung mga workers po ay hanggang sa ngayon ay contract workers pa rin sila. So, ito po ay nagpo-provide ng opportunity para makapag-apply sila ng CNMI resident status at kailangang ma-establish ang process within 180 days beginning 90 days after the enactment date of this law. Okay? DHS may authorize employment while waiting on the decision on CNMI resident status, limits access of CNMI residents to use of public assistance. Okay. All right. So, ang susunod nating provisions na pag-uusapan ay tungkol dun sa pagpapabilis ng immigrant visa para doon sa mga family petitions. Bakit ba nagtatagal ang processing? Hindi po dahil sa lawyer. Yung sa family petitions. Kasi kung hindi ka immediate relative, remember, dun sa iba kong presentations, pinaliwanag ko na, di ba, ang immediate relative, siya po yung spouse, and then yung children below 21 unmarried ng US citizen. Sila po ay immediate relative at hindi sila nakikihati sa quota, sa numerical limits ng visa. Okay? Kaya mabilis ang kanilang proseso, hindi sila naghihintay. Pero kung hindi ka immediate relative, so say overage ka na anak, or may anak ka ng US citizen, may asawa ka na, o kaya ay kapatid ka ng US citizen, matagal ang paghihintay kasi maraming applications na nanggagaling sa Philippines. At kumbaga, ang processing ay ayon sa priority date. So, kung sinong mauna, yun ang pinaprocess. And especially for the F4 category, yung mga kapatid, talagang matagal. And sometimes hindi na nila ina-expect na darating, but all of a sudden, after 15 years, 18 years, ayun pala, buhay pa rin pala yung petition. So, ano po ang solusyon dyan? Okay, so ito po, ayon dito sa bill ni President Biden, Subtitle A, Title 4, Reform of Immigrant Visa System, Promoting Family Reunification, i-recapture yung unused family-based green card and allocates to family immigrant categories. Ito po ay magli-lift ng FB cap from 226,000 to 480,000. Okay. So, madodoble po siya. Ang ibig sabihin nito, mas maraming ma-accommodate and then mas bibilis ang proseso. The worldwide level of employment-based immigrants is increased. Ito yung sa employment naman. Marami din tayong mga applications dyan. 140,000 to 170,000. So, magkakaroon ng increase of 30,000 every year. As I said, proposed law po ito at dadaan pa po ito sa proseso. And so tatapusin muna sa Kongreso, kung ano mapagkasunduan nila bago po dadating sa Pangulo, and the President will sign this. How do you, what can you do para suportahan po ito? Diba? We're gonna talk about that later. Okay, etong isang category, Section 3102, maganda po ito. Reclassification of spouses and minor children of lawful permanent residents as immediate relatives. Ito na-explain ko kung ano yung immediate relatives. So ayon dito, yung F2A category, sila yung asawa at anak ng permanent residents. Hindi sila kinoconsider na immediate relatives, so naghihintay rin sila. Although right now, hindi naman masyado matagal ang paghihintay nila. But still, kasama din sila dun sa quota. Okay. So, ang sabi dito ay itatrato na silang immediate relatives, which is very good. So that means hindi na sila makikipag-agawan sa immigrant visa, and ang immigrant visa will always be available para sa kanila. Okay? Pati rin dun sa mga ang petitioner na US na ang kanilang spouse na petitioner ay right now, kung namatay ang petitioner mo ay na US citizen, ay makaka-avail ka nung widower humanitarian process. Pero sinasabi dito sa proposed law na idadagdag na pati kung ang petitioner ay lawful permanent resident lamang. Parang ang haba nun ah. In other words, kung dati po ang petitioner na US citizen lamang kung mamatay ang makaka-avail yung spouse nung proseso ng para sa mga widow, yung humanitarian relief para sa mga widow. Ngayon, kung ang petitioner ay lawful permanent resident, ayon dito sa proposed law na ito ay kasama na doon. Okay, so magkakaroon ng increase ang per country limit from 7% to 20% and from 2% to 5% for dependent areas. Ang epekto niyan, pag nag-increase kasi yung kanilang limit ay bumibilis. Of course, kasi maraming na-accommodate for that year. Promoting family unity. Have you heard of the 3 or 10-year bar? Okay, so ito po yung mga nag-overstay ng 180 days or a year. Mayroon pong bar na natitrigger kung lalabas ng US. Say, meron akong tourist visa and then nag-expire na yung status ko for 180 days or more. And wala akong any application submitted, while my visa is still good, okay? Kung aalis na ako sa US, if I'm going to leave the United States and go back to the Philippines, matitrigger yung bar na 3 or 10 years. Kaya nga sabi ko, kung meron kayong overstay situation, ay ang payo ko ay makapag-usap po kayo sa inyong immigration lawyer dahil pag na-trigger ang bar, ay hindi kayo makakabalik sa US for 3 or 10 years. Although may mga waivers naman na available, depende kung ang iyong sitwasyon ay papasok doon sa eligibility requirements ng waiver. Okay, making a false claim to citizenship is not a ground of an inadmissibility or a ground for removal if the claim was made before the age of 21. Ito kasi, syempre yung mga bata na dito na lumaki na hindi naman nila naiintindihan na hindi pala sila US citizen at nag-claim sila na US citizen sila. So ayon po dito sa proposed law ay ang making a false claim, hindi na po siya ground of inadmissibility or ground for deportation or removal kung ang claim was made before the age of 21. Okay. Section 3106, exemption from immigrant visa limit for certain veterans who are natives of the Philippines. Ito po yung mga veterano natin. Those eligible in the F1 or F3 categories who have a parent who naturalized as a Filipino veteran are not subject to numerical limits. So tinatanggal na sila dun sa pagiging subject sa numerical limit, and then ang ibig sabihin nito ay ang immigrant visa will be immediately available. Maganda po ito. Paano natin ito masusuportahan? Okay. Tayo pang nandito sa US, the way that we can support this is tawagan po ninyo ang inyong mga senador, tawagan po ninyo ang inyong mga representatives, and express to them your support dito sa bill na ito. Kung kayo po ay ayon dito sa proposal na ito, especially those dun sa may mga kamag-anak, may mga beneficiaries na mga kapatid, mga anak na overage na matagal nang naghihintay, ay ipakita nyo po ang pagsuporta ninyo. Call your representatives and let them know what you feel. Kasi tayo pong mga Filipinos, alam nyo, we do our best na mag-comply dun sa proseso, di ba? In fact, ang dami nga nating applications from the Philippines. And because of the numerical limitations, talagang matagal po ang waiting time natin. So ito po ay isang opportunity para ipakita natin ang suporta natin dito sa bill na ito at nang mapabilis po natin ang pagdating ng ating pamilya from the Philippines, we can be reunited with our family members. At pati na rin po itong mga Filipino veterans natin yung mga kanilang mga beneficiaries, yung mga relatives nila na ang tagal-tagal na po naghihintay, marami po mga veterano ang pumanaw na and nakabitin ang mga beneficiaries. So let's support them. Okay? All right. Section 3107 para sa mga fiancé or fiancé child, fiancé visa. Okay, fiancé or fiancé child status protection. Yung K2, yung anak ng fiancé, ayon dito sa Section 3107, it freezes a K2 child's age on the day the I-129F is filed. It allows fiancés and their children to apply to adjust status without the requirements of a K1 immigrant visa or labor certification. Pinoprotectionan niya po itong minor child from aging out. This is retroactive going back to the 1986 Immigration Marriage Fraud Amendments. Cases may be reopened if motions filed within 2 years of enactment of this bill. So magandang child protection po ito para din sa mga K2 o yung mga anak ng K1. Section 3109, inclusion of permanent partners. Okay. It makes permanent partners equivalent to spouses for immigration purposes. A permanent partner, ito, define niya kung ano yung permanent partner. Let me just explain this. Kasi ang esposo sa immigration, for immigration purposes, ay yung yung kasal na legal lamang po. So ito ay gusto niya nang i-include yung mga permanent partners kahit hindi po kasal. Okay? So permanent partners equivalent to spouses for immigration purposes. Ang sabi dito, a permanent partner is a person 18 or older who is committed in a committed intimate relationship with another individual 18 years or older in which both parties intend a lifelong commitment. So may age po 18 and 18, nasa committed intimate relationship, financially interdependent with such other individual, not married to, hindi kasal sa iba, or in a permanent partnership with another person, unable to marry in home country, yung mga hindi makapagpakasal sa kanilang home country. I would say, ang example po dito, isa sa mga examples po yung same-sex marriage. Dahil hindi naman po lahat ng bansa ay kumikilala sa validity or legality ng same-sex marriage. In fact, sa Philippines ay hindi pa po ito kinikilala. Pero of course, dito sa US ay kinikilala na siya. Pero ang problema is kung hindi sila makasal doon sa kanilang sa home country ng non-citizen partner dahil nga hindi kinikilala ang same-sex marriage. Ang sabi dito sa proposed law ay makikilala na ang permanent partners as equivalent to spouses for immigration purposes. Final requirement, ayon dito sa proposed law, hindi dapat blood relations, not first, second, or third degree blood relation. Okay? All right, so pati yung definition ng child, yung stepchildren. Right now, po pwede kasing i-sponsor, di ba, kung ang petitioner ay nagpakasal sa non-citizen spouse na may anak below 18 years of age, nangyari ang pagpapakasal, ay tinatrato ang bata na child. Okay, yung stepchild na yon as child nung petitioner. So pwedeng i-petition. Ayon po dito sa proposed law, kahit hindi kasal, permanent partnership pa lang. Basta ang bata ay below 18 years old. So ang anak nung non-citizen partner ay below 18 when the permanent partnership was formed, ay pwede na pong kilalanin bilang child or stepchild for immigration purposes. Technical definition po yan. Pasensya na. Kasi hindi lahat ng stepchild ay stepchild sa immigration, so may age requirement. At ito nga ay sinasama na pati ang permanent partnership. Yung formation ng permanent partnership dapat mangyari bago mag-18 years old ang bata para ma-consider ang bata na stepchild for immigration purposes. Yun ang maganda explanation. Napaka-technical kasi ng immigration law. Okay. All right. Ano pa ba? Mahaba pa po ito. About the, ano naman, yung mga high-skilled immigration reform, mga high-skilled immigration, high-skilled workers natin. Okay, first, yung mga graduates ng STEM, okay, F1, international students in F1, at an institution of higher education, basta STEM po, ayon dito sa proposal, ay maaari pong mag-apply directly for permanent residence. Okay. So, dapat graduate degree, ano? The bill increases immigrant visas in employment-based third preference categories. Ito yung other workers from 10,000 to 40,000 a year. So nagdagdag ng 30,000 visas a year, immigrant visas a year. Meaning 30,000, additional 30,000 green cards a year. Okay? And yung mga children of H-1B workers are also protected from aging out if the child accompanies the primary visa holder and acquires their non-immigrant status before turning 18 and are awaiting green card. So yung mga anak, protected din. All right. So we want to thank Ayla for this summary. 32 pages. Pinili ko na lamang po yung mga nag-a-apply sa ating mga Filipinos. Like yung diversity lottery na nag-increase din yung number ng immigrant visa available. Ay hindi ko na, you know, hindi naman po tayo kasama sa diversity lottery. Okay. All right. So mahaba pa po ito. We're gonna do a second round. Ang mga importanteng provisions na pinag-usapan natin, yung path ng undocumented. Importante po. Mabigyan sila ng pagkakataong maging legal. Yung mga dreamers natin. And we're gonna do a second round. Ang haba po niyan. But we got most of it. And how do you support this bill? Call your representatives. Call your senators. Let them know that you support this. Suportahan po natin ang pamilya ng ating mga Filipino veterans na kasi po itong parole for their beneficiaries, diba? Si President Trump ay pinahinto po ito. So, suportahan po natin itong bill na ito. Yan po ang ating presentation today. If you have any questions about immigration law, you can email me, eb@eborlaw.com. Every Friday is free consultation. At until next time po, maraming salamat. Maraming salamat for letting me share my insights sa inyo and for making me a part of your night. Thank you po.